All right, thank you for joining us. Just as a reminder, we are recording this webinar today. Wanted to welcome you to our Lunch and Learn webinar series. Today's topic is compliance. Just a couple housekeeping things. At any point during the presentation, if you have any questions, you're welcome to submit those questions in the chat. You will notice in the chat, we also have a copy of the slides available for download. And when the meeting's done, the recording will be saved in the chat as well, so you can access that recording later if needed. We just have a little bit of a disclaimer here. As you know, we are a consumer reporting agency. We are not attorneys. So anything information provided in today's webinar is educational and should not be considered legal advice. With me presenting, this is Stephanie Peer. I'm in compliance and special projects, but presenting with me today, we have Alicia, who is our Director of Compliance and Operations, as well as Heather, our Client Relations Specialist. Today, we're going to be covering several compliance topics, including 613 letters, the adverse action process, permissible purpose, verifying records with PII, a look at CRA reporting, and the National Federal Criminal for comprehensive screening. At the end, we will have time to address those questions that you submitted in the chat. So we will be covering those at the end. Our first topic today is 613 letters. Section 613 of the Fair Credit Reporting Act requires CRAs to do one of two things if a public record is reported and is likely to have an adverse effect on a consumer's ability to obtain employment. So the first option that a consumer reporting agency like Reference Services has is to notify the consumer by a 613 letter about the public record information and who that information is being reported to. Or the second option is to maintain strict procedures to make sure that the information being reported is complete and up to date. So for that purpose, that means that the current public record status at the time of the report needs to be what's on the report. So in order to get that current public record status, we choose to do county searches to make sure everything is current at the time of the report. So you may have noticed that I said that we have a choice as a consumer reporting agency to do one or the other, but actually at Reference Services, we choose to do both of these things to ensure compliance with Section 613. So to show you an example, you can see the sample 613 letter here. It just lets the candidate know that public record information is being reported about them and who that information would be going to. And it also lets them know if they would like to request a copy of their report and/or dispute any information in the report, they can contact us at that number. We do send a 613 letter for all public records reported for employment purposes. And under the Fair Credit Reporting Act, a volunteer permissible purpose is treated as employment. So we do send the 613 letters for volunteers as well. Another thing we wanted to note was that social media checks are considered public record. So if you're using Reference Services for social media checks and something comes back, we do send a 613 letter for that purpose. So that covers our compliance with Section 613 of the Fair Credit Reporting Act. Now I'm going to turn it over to Alicia to provide some information on adverse action.
All right, thanks, Stephanie. So, adverse action is the next step in the process if you decide not to go forward with the individual based on something in the background report. And the FCRA defines adverse action as denial of employment or any other decision for employment purposes that adversely affects any current or prospective employee. An action taken or determination that is made in connection with an application that was made by or a transaction that was initiated by any consumer and adverse to the interests of the consumer. So basically, the adverse action letter lets the applicant know that there is something negative in the report that you're going to base your hiring decision off of. But not just termination or job denial. It includes anything that could be viewed negatively by the employee or cast them in a negative light. So that would also include being denied a promotion, a pay raise, etc. It also includes adverse outcomes of tenant screening, such as denying an application or requiring a higher security deposit. RSI has customized adverse action letters and supporting documents built into the RSI platforms for your convenience. And the adverse action process is 3 steps. So the first step is the pre-adverse action notice. And this notice is provided to the consumer along with a copy of the report and a copy of summary of the consumer's rights under the FCRA to give the consumer the opportunity to dispute information on the report. And then this starts the waiting period. So the waiting period is usually 5 days, as that is the minimum amount of time required by the FCRA. This gives the consumer time to dispute the report. And if that happens, we would notify you right away, and then you would want to hold that position while we research the claim ASAP. And then the third step of the process is the post-adverse action notice. If you haven't heard anything from us in the 5 days, then you will want to generate the post-adverse action notice. This will include contact information for us, the CRA, again, the summary of rights, and a statement that the CRA did not make the decision to take adverse action. And now I will go ahead and give the floor back to Stephanie. She's going to cover permissible purpose. Stephanie, I think you're on mute.
Thanks, Alicia. So just a few things I wanted to cover in terms of acronyms. You may have seen these, heard these previously in the presentation, but we just wanted to make sure everyone is on the same page. So the CFPB is the Consumer Financial Protection Bureau. The FCRA is the Fair Credit Reporting Act, and the CRA is a consumer reporting agency such as Reference Services. So we just also wanted to point out that the FCRA, Fair Credit Reporting Act, governs not only credit reports, but all consumer reports. And any report that you would receive from Reference Services is considered a consumer report, whether it contains credit information or not. So the Fair Credit Reporting Act governs pretty much everything that Reference Services does. There are strict limitations on who can run background checks in order to protect consumers and their privacy. The company running the background check is required to have permissible purpose as defined by the FCRA. So CRAs, like Reference Services, are required to credential all clients, and part of that process is to confirm that the client has permissible purpose to run a background check on consumers. In July 2022, the CFPB released an advisory opinion reconfirming that CRAs can only provide reports to users with permissible purpose, but they also added that the permissible purposes are consumer specific. So that clarification, to kind of dive into that a little bit more, means that permissible purposes apply only with respect to the consumer who is the subject of the user's request, meaning information not about that consumer should not appear in a consumer report, which on the surface seems like a no-brainer. Of course, we don't want to send information about a different person on a consumer report to someone that's trying to make an employment decision. To add another layer of complexity to this, they added that name-only matching does not satisfy the requirement. So this means if you have a record that's being reported and it's a name-only match, this is not following reasonable procedures to assure maximum possible accuracy of the information being reported. So at RSI, we always strive for at least 3 identifiers on all reported records to ensure our reports are as accurate as possible. So we don't rely on the name-only matching. In addition to making a report potentially inaccurate, the use of poor matching procedures, such as name-only matching, can lead to violations of the FCRA's permissible purpose provisions, because if it's a name-only match, you can't guarantee that the consumer report pertains only to the consumer that the information was requested on. So to kind of clarify further, I have an example of this. So if you ordered a report on someone named Joe Smith with a date of birth January 1st, 1990, and records are returned, but the only identifier on those records is the name Joe Smith, you can see that the record could possibly be for your Joe Smith, but it's also very likely that the record could be for a different Joe Smith whose information you don't have permissible purpose to view. So in this example, a CRA is not permitted to provide that record. One, because we can't confirm the accuracy of the information without additional identifiers, but also because reporting that information would violate the permissible purpose provisions if the record is actually about a Joe Smith that is not your applicant. So you as an employer wouldn't have permissible purpose to see that information. You should only see the information that we are certain pertains to the Joe Smith in your applicant pool. So hopefully this helps explain how a name match only would not only be considered inaccurate, it would also potentially be a violation of the permissible purpose statutes in the Fair Credit Reporting Act. So now we are going to move on to our next topic, and Alicia is going to pick up with an update on Michigan, PII, and clean slate law.
All right, so yeah, Michigan has a couple of things going on right now. So the first I'm going to cover is the clean slate law, which states criminal records will be automatically expunged if specific conditions are met. I think it was April of this year that this is going into effect, and it's kind of a process that they're going through right now. So up to 2 felony convictions will automatically be expunged the later of 10 years after sentencing or the person's released from custody. And up to 4 misdemeanors will automatically be expunged 7 years after sentencing. The following convictions are not going to be eligible for the automatic expungement: convictions for assault, convictions for serious misdemeanors, convictions for offenses punishable by 10 years or more in prison, convictions that involve a minor, a vulnerable adult, injury or serious impairment of a person or the death of a person, or convictions that involve human trafficking. Michigan also has been one of the states removing PII, or personally identifiable information, including date of birth, due to risk of identity theft. So this poses a hardship for employers because it slows down the hiring process. And kind of as Stephanie mentioned on the last slide, it makes it difficult for CRAs to report these records because we don't have those matching identifiers that we're looking for. She stated that we always look for 3 solid matching identifiers. The FCRA requires at least 2 identifiers. So as she mentioned, those John Smiths and those common names without a date of birth and maybe an address also, it makes it super difficult for us to match that record with the applicant. And there are a few other states that are also following suit with this. California has been in the process now for a little bit. So we're going through that with them. Colorado, we have heard, is expected to follow suit as well. So we are working with our vendors constantly to find workarounds for these issues and to get special permissions in those jurisdictions. But it's quite a process that we're going through. So just a few points on CRA reporting. No address history is seen on the background check because it is not an FCRA compliant product. The Social Security trace is a tool that's used to populate alias names and jurisdictions for the searches and cannot be used for an employment decision. So therefore, the information that the Social Security trace generates, which is the address history, is not going to be available on the background check itself. It's just something that we use. Some states have employer use laws, not CRA reporting laws. So we go by the federal rule unless there's a state law that supersedes the federal guidelines. Under the FCRA, convictions are reportable forever. However, our policy at RSI is to report misdemeanors for 10 years and felonies forever. If you have another preference, just give us a call and we can customize the reports, put special instructions on there so that our order review department knows exactly what you want to see on your reports. Non-convictions, pending, and deferred charges are reportable for 7 years from the charge or file date. With that being said, we in our order review department are going to read the sentencing. And if, for example, a person completes a deferral program 2 years after the deferred disposition date, then we are going to hide that charge because it is then considered dismissed. And we never report sealed or expunged records. These shouldn't even be available to us to see, to pass on to you. So, and Heather is going to share some information on parental signatures for minors.
Thank you, Alicia. Hello, everyone. So just to make sure all of our clients are aware, if you are screening a minor and you are using our applicant self-entry system, the system is not set up to obtain a second signature. However, you are required to get a parent or guardian signature prior to screening any minors. We do have those templates. If you need those, please just reach out to our help desk. We can get you those templates, but just keep in mind that you should always be getting a parent or guardian signature before screening a minor.
All right, and now we're going to turn it back over to Stephanie to cover negligent hiring.
Great, thank you. So on negligent hiring, the definition of negligent hiring is the failure of an employer to investigate a job applicant's work experience, character, criminal history, and other relevant data prior to the hiring of an employee. So employers are responsible not only for what they do know about an applicant, but also what they should have known about what they should have known about their employees. So employers lose approximately 79% of negligent hiring cases, and the average claims are over $1 million and climbing. The Professional Background Screening Association now reports that plaintiff lawyers are no longer simply asking whether your company ran a background check. They are assuming that some type of background check was performed. So the question now is leaning towards, they want to know how comprehensive the background check was that you've done. So if you're running only a nationwide criminal in the current county of residence, that, for example, may not be good enough. It may not be enough information you could potentially be missing out on information that you should have known about an employee. Our most comprehensive criminal screening package is listed here, and it includes the nationwide criminal with alias name search, including a sex offender registry search, the Patriot search, and a social security trace. You can see it mentions address history, but like Alicia said, we don't provide address history in the results, but the address history is an important tool in generating a comprehensive criminal screening because it gives us the information needed to know which county criminal searches to run. We do recommend generally going back in 7 years of the address history, and our system is set up to automatically pull that in so that you don't have to worry about something being missed. So any addresses in their social security trace within the past 7 years, a county criminal search can be automatically added to cover that jurisdiction. And the last piece that is important is a national federal criminal. And this is the only place that federal crimes are going to be reported. This includes any crimes brought by federal district courts. So that includes things like drugs across state lines, medical fraud, financial fraud, etc. So if you are in banking or healthcare, for example, if you're not already running a federal search, you should seriously consider running that search. If you are interested in adding that or any other search listed here, we can certainly help you add that to your screening package. So if you'd like to talk about adding any services, please email sales@referenceservices.com, and we can work with you to make sure you're running a comprehensive criminal screening. So some of the key takeaways for today. Make sure that the RSI team is aware of any special instructions that you have for reporting on your background checks. Consider your state laws and your company HR policies, and then schedule a call with the RSI compliance team to discuss. And like Alicia said, we can work to put special instructions on your account to accommodate any reporting requirements that you have for those public records. And to start that process, you can email compliance@referenceservices.com. Okay, so it's almost time for the Q&A. So just remember, you can submit questions in the chat. If you have any questions, you can put them there. And it's just before we jump into that, just a reminder, the slides for the presentation are also in the chat window. If you scroll all the way to the beginning, you'll find those slides available for download. And once the recording completes, you'll also be able to access the recording of this webinar in the chat area. Now I'm going to send it to Heather, and she's going to take a look at any questions that may have come in during the presentation.
Thank you, Stephanie. Okay, I just had one question pop in. What are the guidelines required for how exactly an adverse action letter is sent to an individual? For example, is a signature required when sending certified mail? So the FCRA doesn't really specify a particular method of generating that letter, whether it be by, snail mail, certified mail, email. Our platforms do support both options. So, you can certainly send it by email. We generally recommend sending it by certified mail just because you do have that proof that it was delivered. But of course, that is not an FCRA requirement. So you can send it, be a snail mail, certified mail, email, whichever you should choose. Joined the webinar late, cannot see the link to the slides. Can that be reposted? You should see it. I do see it up at the very beginning of the chat. It was posted by Brad O'Dill. If not, Doug, I can certainly send it to you. I'm just making a note. Oh, I've got a few people saying they do not see the slides.
I'll try to repost it, Heather.
Okay, so Stephanie will repost that. And then does the adverse action letter automatically get sent out, or is that the responsibility of the employer? Yes, that is the responsibility of the employer. Since you are the ones making that hiring decision, the adjudication process is completely up to you. So if you see a background check that causes you to deny an employee, you will log into your system and generate that adverse action. Now, our platform does make it very easy, generally 1 to 3 clicks to generate that, and it will include everything you're required to send. But that does fall on the responsibility of the employer. And I think that's the last question. We just have a lot of comments that nobody can see the slides. As Stephanie did mention that she will be adding it to the chat feature. Let's see, one more question just popped in. Are you aware of any special reporting requirements for federal contractors doing background checks? I mean, other than ensuring you're doing that national federal, I am not aware. Alicia might want to chime in if she's aware of anything. I'm pretty confident that any federal contractor would be required to do that comprehensive package that includes a national federal search. And another question, does sending the adverse action letter apply to churches or organizations running checks for volunteers? It is considered best practice. So even though they might not be getting paid, I don't think that's necessarily required under the FCRA, but it is recommended just to let them know that you might be declining them based on their consumer report and give them that opportunity to dispute their background check. Is there a look back period for what we are allowed to consider based on what we see? So bottom line is anything that you get on a consumer report, you are allowed to consider. So that is our job to make sure that you are only seeing items that you're legally allowed to consider for making a hiring decision. So if you see it on the background check, you can use that as consideration for employment.
And I just want to jump in, Heather, and mention the CRA reporting requirements in certain states do differ from the employer use requirements. So we mentioned, I think Alicia talked about that. So if you are in a state with different employer use requirements, please contact us and we can customize your reporting.
Thank you, Stephanie. Somebody's asking to repeat what we said about the CRA reporting. You mentioned felonies show forever. How long for misdemeanors? So reference services standard reporting is felonies for a lifetime and misdemeanors for the last 10 years. Again, taking into consideration whatever that state law is. What if the charge is pending? Should I still consider? So again, if it is on your consumer report, you can use it to make your hiring decision. Thanks for trying to repost the slides. However, the reposted link to the slides does not seem to be working.
Okay, so I'm unable to make any attachments, and I believe it could be because I'm not the creator of the webinar. And I believe that ability is only with the creator. So we will, I believe, may have to email out the slides for everyone.
And the comments from 720, please repost the PDF. Or I'm assuming, Shannon, you're referring to the slides from our last Lunch and Learn. I'm not sure what comments. Stephanie, do you have any idea what comments from 720?
I think 720 is where we posted the actual PDF document, and I tried to share it, see if it would
okay.
work.
Okay, so yeah, as far as the slides go, we will get that emailed out as soon as possible to everyone who attended. And I don't see any new questions coming in other than the the slide request, and we are at the 11:30 cutoff. So I guess that wraps things up.
Yes, thank you, everyone. I'm going to go ahead and end the recording, and it should be available for download shortly. Thank you so much for attending.